Welcome to San Joaquin College of Law Today, a show dedicated to issues and events within the law school which are of general interest as well. SJCL Today is produced by San Joaquin College of Law, a nonprofit law school in Clovis, founded in 1969 to provide quality legal education. Over 88% of its graduates have passed the California bar examination. More than a quarter of the practicing lawyers in the Fresno area are San Joaquin College of Law graduates. We begin our show with an inside look at the law school's radio show. Valley Views on the Law airs the first Thursday of every month on KFCF 88.1 FM in Fresno. The program's dedicated to the exploration of the legal aspects of local issues. Valley Views on the Law is hosted by constitutional law professor Jeffrey G. Purvis and Remedies professor Justin Atkinson.
Welcome back, O ye multitude of listeners. Today is an epoch-making Valley Views on the Law for a variety of reasons. First reason, driving over here, I learned that they're canceling, NPR is canceling Talk of the Nation, which really ticks me off. It's just another indication of the corporatization of America.
Neil Conan says he wants to take time to figure out what he's going to do, but I mean,
more time with his family. Yeah.
What's NPR without Neil Conan?
That's just wrong.
It is.
Or Ira Flato.
Yes.
Science Friday. Secondly, this is the first Valley Views on the Law that will be filmed for television or recorded for television. Mm-hmm. Film is a term used by old geezers like myself. And thirdly, once again, for the first time ever, our guest has stood us up and has not shown up for the interview because he misunderstood that we wanted him here to do the interview. So we were going to discuss the move to amend a proposed constitutional amendment to reverse the Citizens United decision with Mr. David Cobb, an attorney who has sued corporate polluters, lobbied elected officials, and who ran for president in 2004 on the Green Party ticket. But Mr. Cobb could not be with us today, so Professor Atkinson and I are going to conduct the interview of however you want to characterize it, an empty chair, a Starbucks cup, or just make it up, and see how that goes over with you, the listening audience. As always, even on this amazing day, I will begin the show with the critically acclaimed and never to be canceled Dear Professor segment, in which I read fabricated emails from imaginary correspondents and then answer them right here on the air. And I remind you, if you'd like to be a guest on our show and stand us up, or if you have an interesting legal question or comment or topic that you would like us to discuss, you can actually send an email to me at jpurvis@sjcl.edu and possibly become as famous as Professor Atkinson and I are for 15 minutes or so. Well, 60 minutes. Dear professors, why does the Constitution make it so difficult to amend the Constitution? I understand that Congress can propose amendments if 2/3 of both the House and the Senate agree. But we have seen that even when one party controls 60% of the Senate, the other party can prevent any action being taken. So how could a 67% consensus be achieved? The other method of proposing an amendment is a constitutional convention, but 2/3 of the state legislatures have to ask Congress to call one. Then, assuming an amendment is successfully proposed, it must be ratified by 3/4 of the state legislatures or by 3/4 of state constitutional conventions, whichever method Congress chooses. Particularly in our modern polarized political climate, PPP, it just seems impossible that an amendment to the Constitution could ever actually succeed. And that is from Alice Paul of Mount Laurel Township, New Jersey. I agree with you, Ms. Paul, that it can be very difficult to amend the Constitution. I believe that there are historical and theoretical reasons that the framers did this intentionally. From a historical perspective, it is evident to me that the framers thought that self-government, however desirable, had inherent dangers, and they must have been concerned, even where only white males with property could vote, that the opinions of voters were too readily influenced by transitory concerns and emotions. Consider that United States senators were initially not elected by the voters, but were selected by the legislature of each state. The Senate was apparently intended to be a more deliberative body, where the wise elder statesmen, with terms of office 3 times longer than representatives, and with only 1/3 of them subject to change in any federal election, could restrain the representatives from taking any rash legislative actions. Even the President of the United States is not elected by voters. The President is chosen by vote of electors in each state, appointed in a manner directed by the state legislature. That's the Electoral College we're all familiar with. The layers of congressional and state legislative action that must be traversed to propose an amendment seems like similar insulation between the Constitution and hasty, passion-driven decisions by the people of the United States. The requirement that a proposed amendment be ratified by 3/4 of the states was probably intended to ensure that any changes to the Constitution would be widely supported and reflect the views of much more than a bare majority of Americans. One of the most important and wonderful things about the Constitution is that it protects certain human interests, what we call fundamental rights, from being completely subject to majoritarian political control. Thus, if one is of the opinion that concentration of wealth in the hands of a few is a great threat to everyone's freedom, one can advocate that all income over $500,000 per year be taxed at a rate of 99%. And no matter how dangerous legislatures thought such an idea was to America, the First Amendment Freedom of Speech Clause should make it unconstitutional for them to enact a law punishing such speech. Or, if your religious beliefs demand that you divest yourself of all possessions and spend your life helping others in need, the First Amendment Establishment and Free Exercise Clauses should protect you from legal sanctions, even if most Americans think your beliefs are false, and that the supernatural ruler of the universe wants us all to acquire as much wealth as possible. The Constitution places these fundamental rights above the ordinary political processes where a bare majority is generally sufficient to make government policy. If the Constitution were easily amended by a majority vote of Americans, that would put all of our hard-won fundamental rights in jeopardy. On September 12, 2001, when many people argued that it was necessary to set aside certain constitutional rights, such as freedom of speech, due process, and the equal protection of the laws, in order to save America from destruction, an easily amended Constitution might very well have been altered to eliminate those freedoms, if only as a temporary measure to ferret out the Islamic terrorists hidden among us. A long and difficult amendment process purportedly forces us to consider all the arguments for and against a proposed amendment fully and carefully, and theoretically gives us all some protection from political decisions driven by fear and hatred. Nothing can guarantee that our society will remain self-governing and will continue to honor fundamental human rights. Constitutions can be amended to deprive people of human rights, as Proposition 8, which is currently before the Supreme Court of the United States, deprived homosexual people of their right to marry under the California Constitution. In my opinion, the best way to maintain our constitutional system is to make sure we have a well-educated populace taught from birth how critical it is to understand and support the rule of law, human rights, and to have compassion for all.
And how to use great alliteration like she did. PPP.
That's good
stuff.
I like that. I think she's a professional writer, possibly.
Yes.
Second, dear professor, dear professors, You liberals are all the same, Professor Purvis, or should I say, you communists. Just because someone is smarter than you are and works harder than you do, and as a result makes more money than you do, you want to tear them down, take away their money, and give it to your lazy friends. Now this Move to Amend organization wants to take away the constitutional rights of corporations. It's just like Senator Cruz said to Senator Feinstein. You leftists want everyone to have the right to have sex with anyone they want, but you won't protect a person's constitutional right to have a gun or spend his money as he pleases. Like the Bible says, the race should go to the swift and the battle to the strong, and you losers should just shut up and get a real job. And that's from John Galt of St. Petersburg, Florida. There is a kernel of truth amongst your dreck, Mr. Galt. Many people seem much more willing to allow government to restrict the constitutional rights that they deem less important than to permit any interference with the constitutional rights that they personally value. The political left doesn't agree that the right to bear arms is a fundamental human right, and argue that government regulation of guns should not receive strict scrutiny by the courts. The political right doesn't agree that a person has a fundamental human right to have an intimate relationship with another person of the same gender, and argues that government should be able to prevent such persons from marrying or put them in prison. It would be far better if everyone took all constitutional rights seriously and remembered that the most important function of the Constitution is to protect individuals from oppression by their own government, including where a majority has voted to approve that oppression. I cannot let you mention the Cruz-Feinstein confrontation without commenting on it. Here is part of what Senator Cruz said. Quote, "Would she consider it constitutional for Congress to specify that the First Amendment shall apply only to the following books, and shall not apply to the books that Congress has deemed outside the protection of the Bill of Rights?" Closed quotes. This is somewhat amusing to anyone familiar with constitutional law, which Senator Cruz most definitely is not. Deciding that certain books or other speech is outside the protection of the Bill of Rights is exactly what state legislatures and Congress do, with the acquiescence of the United States Supreme Court. For example, publishing a book that is judged obscene, as that term is defined by the federal courts, can be made a criminal offense. Speech that constitutes child pornography or false advertising or certain kinds of threats are all given little or no constitutional protection under the Free Speech Clause. So it would not be without precedent for certain types of firearms to be classified by Congress as so dangerous and so different from the arms available to the framers to be outside the protection of the Second Amendment. But today's topic is not the Second Amendment, it is the First Amendment and freedom of speech. Constitutional scholars and judges are in broad agreement that the Freedom of Speech Clause was intended to protect political speech from government interference or control. For a self-governing democratic republic to remain free, it is vital that the people be able to discuss, debate, and criticize political candidates and government policies. If fundamental rights can be ranked, freedom of speech must be one, if not the most important rights. Everyone should agree that it is be protected vigorously and assiduously by citizens and by the courts, and we should think very carefully before giving the government more power to regulate political speech, or speech generally, in any fashion.
Who is John Galt anyway?
Exactly.
Sorry.
Do you know who he is?
Yeah, Atlas Shrugged, right?
You're so well read. I'd like to not welcome back our absent guest, Mr. David Cobb, and I won't be able to ask him to tell us about himself and why he became involved in the Move to Amend movement. And of course, as he's not here and I don't have to be polite to him, I won't hesitate to suggest that as a former presidential candidate, he just wants to be in the spotlight. I suppose that might technically not be fair, but it's his fault. He's not here. So rather than ask him about move to amend, I'm going to read what the actual proposed amendment is, which I got from the Move to Amend website on the famous interwebs. Section 1, bracket, corporations are not people and can be regulated, closed brackets. The rights protected by the Constitution of the United States are rights of natural persons only. Artificial entities, such as corporations, limited liability companies, and other entities, established by the laws of any state, the United States, or any foreign state, shall have no rights under the Constitution, and are subject to regulation by the people through federal, state, or local law. The privileges of artificial entities shall be determined by the people through federal, state, or local law, and shall not be construed to be inherent or inalienable. Section 2, bracket, money is not speech and can be regulated, closed brackets. Federal, state, and local governments shall regulate, limit, or prohibit contributions and expenditures, including a candidate's own contribution and expenditures, for the purpose of influencing in any way the election of any candidate for public office or any ballot measure. Federal, state, and local government shall require that any permissible contributions and expenditures be publicly disclosed. The judiciary shall not construe the spending of money to influence elections to be speech under the First Amendment. Section 3, there's no bracketed description for this one. Nothing contained in this amendment shall be construed to abridge the freedom of the press. What I would have asked Mr. Cobb, had he graced us with his presence, and thus I believe Professor Atkinson has agreed to channel Mr. Cobb.
I will attempt so. See, I will channel him.
I have no idea how Professor Atkinson is going to do this, but I'm sure he is up to the task.
Let's try it.
I was going to ask him, if money is not speech, would a human have a constitutional free speech right to spend money to engage in speech? For example, if I were a person, a human being, which I reputedly am, with some spare cash, and I wanted to pay a television broadcaster to allow me to be filmed, possibly as we are right now, and broadcast that to the American public to communicate my political ideas, would that be considered speech, or could the government prohibit me from spending my money to purchase that airtime?
Well, Professor Purvis, thank you for inviting me on the show. First of all, I think the government could, in fact, prohibit me from doing that. I think what I should do is get a big soapbox, and I could jump up on top of that soapbox and yell, and whoever could hear me yelling, I think that would be free speech. But if I pay anybody any money, radio, whatever it may be, then that can be regulated.
Well, suppose you had answered that no, of course, that would not be prohibited because...
Okay, no, it would not be prohibited. Of course I can pay somebody.
That was an excellent answer.
Okay, of course I can pay somebody to...
But I had a follow-up question.
Right, okay.
Changing, as law professors are wont to do, tweaking the facts a little bit to explore the legal ramifications, as I'm sure you're familiar. If I'm allowed to speak, and you immediately recognized, you're a perceptive person, Mr. Cobb.
Thank you.
That the issue here is the mode of communication of a person's speech or ideas to his fellow citizens. So you can get on a soapbox, you can get a bullhorn, but people, after President Lincoln was elected, standing on a stump,
yes.
People found that that wasn't an effective or efficient way to reach people in the growing nation. So they invented print, newspapers, and writing. And then after Marconi came up with radio, and whoever invented television, I think it was Al Gore.
That was the internet.
They have these other modes of communication, which in our modern world often require the expenditure of money. So if I don't want to go on camera because I'm not telegenic like you or Mr. Cobb, and I want to hire someone attractive and young and appealing to the masses to state my message, state my message on a soapbox, or perhaps I don't have a mellifluous speaking voice, which I actually do for radio purposes. I want someone else to do it. Would paying that person violate or be regulable under your proposed constitutional amendment?
Well, I think paying someone with a mellifluous voice to speak on the soapbox, I think that's under the amendment. I think that falls within the parameters of what can be potentially regulated under what my amendment is, correct? I mean,
money is not speech.
Money is not speech.
That seems to be the thrust of Section 2.
Well, it makes it very easy. All this symbolic speech is if I want to go and buy a Papa John's pizza because I'm anti-Obamacare. If I want to buy some Chick-fil-A, it makes it much easier. The constitutional analysis is much easier now because is that symbolic speech? No, money's not speech, so we're done.
Doesn't, Mr. Cobb,
yes,
limiting the ability of a political candidate to expend money for speech purposes limit that candidate's opportunity to communicate their message to the voters in a way that's very destructive of our representative form of government?
Okay, I need to channel Mr. Cobb here. What would he say?
Remember, money is evil,
mm-hmm.
and you don't need money to engage in speech.
Yes.
I would assume would be your position, sir.
That is my position. And there are other ways that I can get my message out there besides that of paying somebody. And I think that if everybody couldn't use money for speech, then we wouldn't have the problem with the 24-hour news people. I don't know where I'm going with this. I'm sorry.
All right. Well, I was going to be diplomatic
yes.
if you were here in person,
yes.
but I have to point out, in my best lawyer-like fashion, that your very website contains extensive resources encouraging people and telling people how to raise money in order to advocate for the Move to Amend movement.
Well, that's different, Professor Purvis, because that's money going to my speech. So, I mean, that's different from anyone else's speech. My speech should be protected because it's the right speech.
Oh, that's right.
Yes.
I forgot.
Okay.
So, other information on your frequently asked questions section of your Move to Amend website is that this amendment and the constitutional principles it will enshrine forever until we repeal it in 10 or 15 years would apply to nonprofit corporations and to unions and other artificial entities. So, for example, the Sierra Club, the ACLU, or the Move to Amend movement, all of their advocacy that was conducted through the use of money, all of their advocacy, since they're an artificial organization, would be completely regulable by federal, state, and local law and could be prohibited. Isn't that absolutely antithetical to our democracy?
Wait a minute. Are you saying that what I'm doing right now could be regulated?
Could be made illegal under your own amendment.
Wow, I didn't think about that.
That's causing you to rethink the whole thing,
It kind
isn't
of
it?
is. I think that you've convinced me, Professor Purvis, that perhaps I should rethink my ideas about this Move to Amend. All the property that the Move to Amend that we hold as a corporation, we couldn't have that anymore?
Well, that's a very interesting point that I also wanted to bring up with you, because your proposed amendment states quite clearly that these artificial entities, including the Sierra Club, the ACLU, any nonprofit organization doing communitarian service in America, have no constitutional rights. So that means they have no constitutional right to due process of law. The Fourth Amendment doesn't apply to them. The Takings Clause doesn't apply to them. The Equal Protection Clause doesn't apply to them. So if the government seized their property, not just limited their speech, but actually caused them to forfeit all the money they had raised using the Move to Amend fundraising techniques and took it away, they could not allege that that was an unconstitutional taking, since the amendment flatly states they have no constitutional rights, which is, again, dropping any pretense of civility, is absolutely outrageous. It's just amazing that any sensible or reasonable group of people could frame what's going on in those terms.
So what's the purpose of an organization being able to hold property? What's the purpose of that? I mean, does that do any benefit? Does that have any benefit to our society?
I think it possibly does, in that the Supreme Court has identified a right called the right of association. It has two aspects, and one that's relevant here is the right to associate for expressive purposes. Political parties, for example, are artificial entities where people are associating together to combine their resources and their efforts to engage in political expression to advocate election outcomes. Under the amendment that you and your people have drafted, the proposed amendment, the government could restrict political parties from engaging in expression because they would have no constitutional rights. And I just think, I'm astonished, first of all, that you're a lawyer. I guess I shouldn't be. Not you, of course.
I know. Just
God.
That was a little...
Well, your reaction, I thought I'd gone a little bit too far.
No.
But that someone who is trained in law would frame it this way.
We need to go back to the good old days where, in order to have, I mean, not in the United States per se, but let's say, pre-1970s Chile, or maybe North Korea now, where if you want to get together and have a political gathering, you have to get together in your basement of your home, and so nobody knows. You have to hide it from your neighbors just in case they talk to the government about it. The government come in and seize you because, of course, they can do whatever they want. So I'm going back to the good old days.
In other words, people in those places have no constitutional rights, the way this amendment would create it for all organizations that were not human beings.
Yes, exactly. So political parties get together in your basements.
One last point. Your website says that your proposed amendment will do away with ambiguity. Yet the last section says, nothing here shall be construed to interfere with freedom of the press. I can't really ask you enough questions in the time I have remaining, but were you aware that most of the press is comprised of corporations and artificial entities about whom you're going to take away all their constitutional rights? Isn't that going to interfere with freedom of the press?
Well, I mean, what is the freedom of press? It's. I mean, I think that they're useless anymore because they're bought and sold by corporations. So if we get rid of the corporations, they have no rights. Then the freedom of the press will be organic.
All right. Well, my last comment that I want to make, since the sound engineer is signaling that she is sick and tired of this game we're playing, is that, like so much of good-intentioned action, I think the motivation for Move to Amend to reduce the influence of wealth on our political processes is a laudable one, but this is an absolutely monstrously bad way to go about that. And we should never amend the Constitution in haste or thoughtlessly or without considering things like that.
Let me ask you this. Would you change your mind if I brought a ukulele player or a drum line or a drum circle?
That suspends my rational faculties. Okay. That brings us to the end of this truncated edition of Valley Views on the Law, presented by San Joaquin College of Law, a nonprofit artificial entity committed to educational excellence and community service. We invite you to join us in the future, particularly if you're one of our guests, as we explore the legal aspects of local issues.
San Joaquin College of Law has 2 free legal clinics operated by students and overseen by faculty members. SJCL students are doing groundbreaking work in non-adversarial property division agreements and divorces in the mediation clinic. Clients meet with a student to work out a marital settlement agreement, which can then be filed with the court. The New American Legal Clinic assists legal immigrants in obtaining citizenship, working through the processes of naturalization. The Now Clinic also assists those seeking family-based immigrant visas or U visas, depending upon eligibility.
Hello, I'm Jessica Smith-Bobadilla. I'm a professor here at San Joaquin College of Law, and I'm also the legal director of the New American Legal Clinic. I have been with the law school for about a year now, and I became a full-time faculty member in October. I teach as part of the clinic, and I also teach an immigration law and policy course. Currently, with the New American Legal Clinic, we're pursuing a number of different events and assistance to the immigrant community and the employer community alike. We are currently operating under a USCIS grant, USCIS being United States Citizenship and Immigration Services, and that grant is focused on naturalization. So we're offering free naturalization screening in collaboration with the Fresno Adult School to a number of different people in the community, and those that have a chance to naturalize, we're offering no-cost representation due to the assistance this grant has given us. So that's allowed us to naturalize a number of people that either couldn't afford legal services to complete the process, or sometimes that didn't know at all that they were eligible to obtain U.S. citizenship at this time. We're also working on a variety of other initiatives with a number of different partners, including we are doing a MCLE, or a continuing legal education course at the law school on April 12th, and that's focused on U visa relief or U non-immigrant status. And that's a status for individuals that suffered generally a violent crime against them or a very close family member, or were a witness to a violent crime. We're doing that event in collaboration with the Immigrant Legal Resource Center of San Francisco and also with the UC Davis Immigration Clinic. And myself and Professor Justin Atkinson from the New American Legal Clinic, as well as a number of representatives of those other agencies and clinics, will be speaking at that event to try to educate the legal community more about immigration options for immigrant crime victims. We're also planning an event here at the law school on Saturday, April 20th, and that event will be focused on deferred action for childhood arrivals, or DACA. Many people refer to it as the DREAM Act, although the DREAM Act was actually something that was proposed in Congress. Deferred action was something announced by President Obama in June of last year, and it allows certain individuals that arrived in the United States at a young age and pursued an education or are interested in pursuing an education, the opportunity to receive a stay of deportation and a work permit for 2 years that's then renewable for an additional period of 2 years. We're working with a number of different community partners on that event, and we're also planning for different professors and local attorneys to give talks to the community about this new program, to be sure people get the best help possible. We'd encourage you to contact the school and contact the legal clinic if you have any interest in what we do in terms of helping us as a volunteer or a partner, or as helping us fund these services, or just coming to see what we do. We're really happy to be offering this service to the community and to be educating students as to the field of immigration law. I'm Jessica Smith-Bobadilla, Professor of Law and Legal Director of the New American Legal Clinic. Thank you for watching.
For the first time in history, San Joaquin College of Law will play host to the Trainer Moot Court competition this year. 14 schools will compete, including teams from Berkeley, Hastings, McGeorge, and Davis. Despite competition from virtually every major law school in California, students from San Joaquin College of Law have performed well. In the past 4 years alone, they've won 4 Outstanding Individual Achievement in Oral Argument Awards and 1 for Best Brief. SJCL Moot Court Director Professor Jonathan Conklin team, and Professor Stanley Boone lead the team. SJCL faculty members also help with practice sessions. This session includes input from Professors Andres Borges, Sally Paring, and Richard Cartier. The team includes SJCL students James Muggeridge and Amanda DeHart, who will argue the case, and George Vasquez, who wrote the brief. He explains the gist of the imaginary case they will argue.
Okay, so for this competition, our case arose from a train accident that ended up killing one of the plaintiffs, or it was the plaintiff's wife who was killed. And along with the plaintiff's wife and the husband were two other family members that were at the scene of the accident. They were all in a tunnel on a nearby a park where they were hiking, and they ended up crossing into this tunnel, and the wife ended up being killed. So the issues of this case have to do with whether the railroad operator owed a specific type of duty of care to the plaintiffs or the appellants. We decided, or we were assigned the appellant side, so we were representing the injured parties. And so the main issue is whether there was a duty of care and whether the stepsister can qualify for bystander emotional distress.
Good afternoon. My name is James Muggeridge on behalf of the appellant. I will be confronting the issue of whether the court properly granted summary judgment based on a finding that there was no failure to warn. My partner, Amanda DeHart, will be confronting the issue of whether or not summary judgment was properly granted as to the bystander cause of action for negligent infliction of emotional distress. May it please the court. Now before the court is the issue of whether or not summary judgment was erroneously made by the trial court. Accordingly, this will be from a decision based on California Code of Civil Procedure 437. Necessarily in that finding was that there was no triable issue of material fact and that the respondent was entitled to judgment as a matter of law. Here, it will be my purpose to show that there were multiple material facts at issue before the trial court, and accordingly that there was not appropriately summary judgment granted as a matter of law. I will be going over three primary contentions. First, that the respondent specifically undertook a duty. I'd be happy to if the court would require it.
That's not how it goes. You start deciding or ask us
for a waiver?
Yeah.
Okay. Okay.
Sorry.
Okay. Would the court like a recitation of the facts?
That's unnecessary.
Thank you, Your Honor.
Well, you got to do it right, and you got to get it to happen.
Okay.
You'd be nervous.
May I continue?
Yes.
I will be going over three primary contentions. First, that the respondent specifically undertook a duty to warn and remedy the potential dangers of the railroad track by first undertaking construction on the railroad and operation of the railroad in 1998. Second, I will argue that the tracks and tunnel did not constitute an obvious danger. And finally, even if the tracks and tunnel and train in combination all constituted an obvious danger, that Rowland applies and the landowner still has an obligation to make safe the premises for foreseeable plaintiffs.
What's the basis for the duty to warn? What's the legal basis?
The legal basis for the duty to warn is based on a theory of negligence. So here there was a landowner's obligation to warn of potential dangerous activities on the premises.
If the danger is obvious, does that duty to warn carry the same weight?
That question needs to be answered twofold. First, an obvious danger is a recognizable defense under California law. And the obviousness of a danger would obviate a duty to warn only if it was not a foreseeable injury to the defendant. Based on Rowland v. Christian, we determined in 1968 that even if a danger on a premises is obvious, that there is still a duty of care. In Martinez v. Chippewa, the court interpreted that duty as a duty to warn or a duty to remedy if it's not something that can be sufficiently warned against. Here, there was...
Were there warnings here, Counselor? Were there signs and postings?
Yes, Your Honor. The warnings that were posted were specifically warnings for no trespassing. And as is commonly known by this court, no trespassing signs are present across the nation, not necessarily, and do not specifically warn of the specific danger of being struck by a train. In fact, based in appellant's brief, we cite to a website that shows that all of the abandoned train tracks specifically in California, and many of those have signs that say no trespassing posted specifically on them. So the duty to warn is the duty to warn of a specific danger.
But you're talking about abandoned railroad tracks. In fact, weren't the railroad tracks in this park still operating and active?
Yes, Your Honor, the railroad tracks in question were active. They were not, in fact, attached to the Cold Stone National Park, but butted up against it. And they were active railroad tracks, but as the testimony from the lower court shows, the appellants believed the tracks to be abandoned based on the deterioration of the warning signs that were spray painted over it and made to the point where they were almost completely illegible.
That would trouble me, Counselor. It troubled me because I read your brief and I see we have weeds and we have knick-knack paddywhack all around this park that makes it look like it's abandoned. But obviously if there's a train that goes down that track, the ties have to be in place, the rails have to be in place. You would think it would become obvious to someone that this railroad track has not been abandoned. It still looks very, very useful and useful.
Well, Your Honor, as we cited in our brief, there are many instances around California where there are still railroad tracks completely in place and have not deteriorated. It takes multiple years for rust to grow on tracks. And as the respondent will undoubtedly point out, there was no rust on the tracks here. However, it was in a bad state of disrepair. There was broken glass, there was no fencing, there was no trespassing signs that were specifically placed there by the railroad in order to warn of a danger, specifically a danger that appellants would argue the danger is being prosecuted for trespassing, not the specific danger of being struck by a train. But there was no evidence that this was active. In McDaniel, was there a question from the court?
I didn't know, you'd said that, does California require specificity in its signage for particular dangers?
In California, there's a requirement that a particular danger be warned of. So specifically here,
Based on what case?
in Delgado, we picked up don't have a really good answer for that yet.
That's a trick question.
Yeah.
Go ahead.
Thank you. In McDaniel, the court specifically held that the respondents picked up or assumed a duty of care based on their building of a fence. That creation of a fence created the illusion of safety there, and once that respondent allowed the fence to fall into a bad state of disarray, the fence itself still appeared to be valid and it appeared to be protective, and it in fact caused the plaintiff danger. In the same way, the railroad here placed no trespassing signs and then allowed them to fall into a poor state of disarray. The no trespassing signs initially may have warned potential plaintiffs that they should not be trespassing on the property. The appellant would still maintain that that warning would not be sufficient in this case, but the respondent in this case is allowing those signs to fall into disrepair created an illusion that there was no longer an active train track here. Specifically, respondent removed benching and shelving from the interior of the tunnel in approximately 2000 based on their recognition that persons regularly trespassed inside this tunnel, so they knew of the danger that existed there.
Do you know when the signs were posted?
The signs were posted in 1994 or 1995. The record below is not specific.
Prior to the time that the benches were removed?
That's correct.
And is there any evidence about upkeep of those signs?
There is no evidence about upkeep of those signs from the record, Your Honor, but we can see from the photographs in the record from the lower court that the signs were in a very poor state of disarray. The respondent will certainly bring out to you that the signs were legible eventually by the appellant, but considering the facts and circumstances of it, you cannot expect that the appellants at the time would have read the signs when they were completely obscured by paint, and there was another group of persons already exiting the tunnel at the time the appellants came upon the tunnel. So it appeared from everyone at the scene, other than potentially the conductor driving the train, that these tracks were in fact abandoned. Next.
Did the trail system where the hikers were using, did it go directly into the tunnel, or did they deviate from the track, from the trail?
The record isn't completely clear as to that point. However, we know that the trails around the Cold Stone National Park led directly into the property. Is it a city park? I believe it was a national park, but I could be mistaken.
Cold Stone?
Either that or your brief is wrong.
City park,
Is it?
Yeah.
Cold Stone City Park. It does lead directly into the railroad tracks owned by the respondent in this case. It's unclear whether or not the trail was intended to go along these tracks. However, that we know from years of use that there were constant trespassers on the tracks, and respondents' own records indicate that they regularly saw trespassers on the track. In January of 2009 alone, there were 15 reported sightings by the railroad of trespassers. So it's not as though the respondents were unaware of the trespassers' presence.
Do you think a sign alone would have discharged the railroad's duties?
Depending on the nature of the sign, no. First of all, no. A sign alone would not have discharged railroad's duties if the sign had existed. There was still knowledge on the part of respondent that persons were still trespassing on the property. Based on Rowland, we know that even when there is a warning of danger, if it's foreseeable that harm... Yes, Your Honor.
I wasn't saying the sign that they had, the no trespassing. What would have discharged their duty to warn?
You mean what would have satisfied the duty to warn? In this case, there would have needed to be a specific signage that says warning active train or something to that effect. Even if that sign had been present, the duty to warn is not the only duty owed by respondents in this case. Based on Rowland, even if there was a sufficient duty to warn, there may have been a duty to remedy if respondents knew that the warning was not adequate to deter persons from...
And how might they discharge that duty?
In Christian, the court articulates several means by which a dangerous railroad condition can be remedied, including lights and other indicia that the railroad is active, or fencing around the portal, not completely such that a train couldn't enter and exit. However, fencing around it to indicate that there is an active train and placing signs on that in a manner that makes them more visible.
Okay, but in this case, the trial court granted summary judgment, and apparently the court below found that either the danger was obvious or there was some other reason why liability couldn't be established. What about the concept of immunity, counsel?
Specifically, I presume the court is referring to California Civil Code Section 846. In Klein v. U.S., the court addressed this almost exact issue on remand. The California Supreme Court addressed the issue on remand from the United States Supreme Court. They addressed the question of whether a landowner is liable for damages based on the recreational use of their property, and specifically when the recreational use is unsuitable to the land. Here, 846 specifically is intended to apply when there's recreational use of the land and that recreational use causes injury. Here was not the recreational use of the land that specifically caused injury. It was the activity based on respondents' activity of running the trains. And in Klein, the court specifically held that 846 is intended to be tied to the proprietary ownership duties of the respondent. Here, it is not tied to the property, the active running of the train. In Klein, the court specifically held that the negligent operation of a vehicle is not designed to be encompassed by 842 immunity. Even if this court does hold that 846 is applicable, there is still ample evidence to suggest that the respondent willfully neglected their duty to warn, which would also allow for liability, because 846 does not specifically immunize respondent entirely from liability. It's only a limited immunization that would, as the court said in Klein, place the trespassers in the position that they would have been in prior to Rowland.
So to wrap up, Counselor, Your argument is that there were tribal issues of fact such that summary judgment should not have been granted.
That is correct.
At the trial level. And you're asking us today to reverse that and remand the case to the trial court.
That is correct, Your Honor. There are many issues here that the court should not have granted summary judgment on. Normally, the court recognizes that a failure to warn is something that should be determined by a jury because it is a question of fact. In addition to specifically the sufficiency of the warning listed.
Is that a factual question or a legal question?
It's a question of fact, Your Honor. The question of whether or not a duty exists is a question of law. However, the sufficiency of the warning is a question of fact for the jury.
And the standard of review for that would be?
Well, here, since we're based on California Civil Code 437, this court has the ability to review it de novo. And does that answer the court's question? Does that sufficiently answer the court's question? So the court here could review based on any finding that the factual record and determination by the lower court was erroneous.
Good afternoon. I'm Amanda DeHart for the appellant discussing the issue of stepsisters Joanne's cause of action for negligent infliction of emotional distress. May it please the court. The lower court improperly granted a summary judgment because the stepsister Joanne and decedent Mary Ann were closely related. Joanne did contemporaneously perceive the negligent act that killed Mary Ann, and the lower court failed to address the railroad's direct duty to Joanne, not just as a bystander. Under Dillon...
Isn't negligent infliction of emotional distress directed towards bystanders?
We're talking about establishing a duty here, and there's two different theories. There's a bystander theory of negligent infliction of emotional distress that has to satisfy certain qualifications that are stricter than a direct victim theory. And in Dillon versus Legg, these standards were outlined because a mother who observed her child hit by a car was not in the zone of danger when she observed the child. So the court laid out criteria that when you're not in the zone of danger, you can qualify for negligent infliction of emotional distress. Here, Joanne was in the zone of danger, so there's a possibility that she may not even need to satisfy these criteria because the railroad owed Joanne a duty directly, a duty of care directly, and in Long v. PKS they addressed this when a foster mother was in a car accident with her foster daughter, and her foster daughter was killed. The mother survived. She did not have to meet the criteria of Dillon and Thing v. Lechuza. She wasn't closely related enough because it was a foster parent relationship. She was still allowed to recover, though, because she was involved in the accident and directly in the zone of danger. And the court said that whether imminent personal bodily harm, fear for one's safety or safety of a third person, whether those could have reasonably been anticipated, are a question of fact for the jury, not an issue of law.
Okay, you're telling me that these people are closely enough related to be within the definition. One, where's the line? Who's not included?
In Thing v. Lechuza, they pared down the requirements laid out in Dillon v. Legg. In Dillon v. Legg, they said it's an ad hoc, case-by-case application. But in Thing v. Lechuza, they recognized that they needed to limit a possibly limitless pool of liability. To be clear, many people experience severe emotional distress based on seeing people they know and love injured or hurt by someone's negligent act. But in Thing v. Lechuza, they drew arbitrary lines in order to limit the plaintiff pool because otherwise just anybody that you feel close to. It's related by blood or marriage and of the same household, a parent, a sibling, a child, or a grandparent. Here, Joanne and Mary Ann were stepsisters. So they meet the first requirement, they're related by marriage. They also meet the second requirement that they're siblings, and they were raised in the same household.
That's a past tense. Your definition that you gave to us said that they share the same household. How much sharing the household do they have to do in the past tense to meet the present definition of the statute now?
Sharing a household isn't actually a requirement. Otherwise, adult siblings wouldn't be allowed to, even blood-related adult siblings wouldn't be allowed to recover. It's that they were a household relationship. And here they lived in the same household from the time Joanne was 2 until the time Marianne was married and moved out.
Are there any cases where siblings who no longer are in the same household have been able to recover?
I don't have any specific cases on point, but I don't know if it's been before the court. I think that especially blood relationships, there's no question. Blood siblings are allowed to recover for one another.
Well, then there should be a case that says so.
There very well may be. It hasn't come before the Supreme Court, and the reason I think that we couldn't find one in any of the appellate districts in the Supreme Court is because it's such a clear-cut, close relationship that I don't think it's been appealed. I don't think it's been argued against. The blood relationship theory application hasn't really been challenged, so I don't think that there are many cases that have made it up through the ranks because it's a clear-cut legal definition.
You mentioned there are two theories. One where the parties are within the household or have that intimate relationship. The other would be bystander. Is that correct?
No. There are the two theories I'm discussing are the railroad's duty. There's one theory that the railroad owed Joanne a duty directly because she was in the train tunnel. The second theory is the bystander theory, and that's the one that the court did the summary adjudication on. That's where they have to be closely related. She has to contemporaneously perceive the injury-causing event, and her emotional distress must be a result of that. That's the criteria for the bystander theory.
What is the family law in California? How does it reference members of the familial unit? Or is it, in the brief, there's a family law component. Does that include stepsisters?
Yes. There are sections of the probate code and the family code that refer to close family relationships as including step-parents, step-children, step-siblings.
Now, is that the guiding category for the courts to consider?
No. The criteria that leads here is Thing v. Lechuza. And Thing v. Lechuza says related by blood or marriage and of the same household or parents, siblings, children, or grandparents. Those are the criteria that must be met. Here they are related by marriage and they are siblings, so they are closely related.
Could they inherit from one another?
Only if they didn't have other very close relations. I think that would get into like further, it's not directly, not like a regular sibling, no. Not like a blood sibling, no. The thing to keep in mind is that Thing v. Lechuza is just trying to pare down the plaintiff pool. The cases where they have not allowed recovery based on people not being close related have been cases where, like in Rodriguez v. Kirchhoffel, the girls were not related by blood or marriage. They had cohabitated from time to time and they loved each other and considered one another sisters. These are the lines the court's trying to draw. The court said in Eldon v. Sheldon, where they did not allow a couple who were not married, were not married, they got into a car accident, the woman died, they did not allow the man to recover, even though they weren't married and they claimed that the relationship was close like that of married people. The court stated that the reason for the arbitrary lines on the closely related category are that they don't want the court to be spending time delving into the personal relationship between these people to truly analyze how close they were. Even though that would be effective, the court said that they didn't want to engage in that sort of investigation into people's relationships. That's why they drew the lines for married or blood or siblings, parents, things like that. And in fact, Thing v. Lechuza said it is arbitrary. There's no question that all of these people in these cases did experience emotional distress as a result of the negligent act of the tortfeasor, and so the lines we're drawing are in essence arbitrary.
And that brings us to the end of this edition of San Joaquin College of Law Today, presented by San Joaquin College of Law, a nonprofit law school committed to educational excellence and community service. The views expressed do not necessarily reflect the position or views of San Joaquin College of Law. This program has been produced in conjunction with the Community Media Access Collaborative. We invite you to join us in the future as we explore issues and events within the law school which are of general interest as well. For more information about San Joaquin College of Law, please visit our website at www.sjcl.edu or call 559-323-2100.